be set at a very high rate, determined by the court and or to remain revoked. These are three different violations of bond. He also has a
Before the case even begins, tension fills the courtroom. Judge Simpson takes the bench, and what's about to unfold is a battle over evidence, or the lack of it. This case revolves around alleged domestic violence and bond violations, yet the defense insists there's zero proof. No police contact, no DNA, no witnesses. From the start, it feels like one side is armed with claims while the other clings to silence. This kind of setup usually means the courtroom will turn into a war zone of logic versus assumption. As the defense begins outlining its position, you can almost feel the frustration. How can someone be accused so heavily when not a single shred of verifiable evidence exists? But stay alert. What starts as a simple request for clarity will soon unravel into open confrontation, credibility doubts, and a furious judge who won't tolerate mistakes.
he has the no contact, he has the no go-to that we have in this case, and so I don't understand what the reason that he needed to reach out for any reason.
Mr. Bench.
Well, Your Honor, is the witness here? Because that is all, and I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denied the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged.
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
Does he want a hearing on the bond violation?
absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. I'm also waiting for the actual screenshots of the text messages that are written in the Romulus police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there.
The defense just dropped a bomb. They've never even seen the supposed screenshots being mentioned by prosecution. This line is where courtroom momentum starts to shift. If one side claims evidence exists but can't produce it, the entire case balance wobbles. From a legal standpoint, unshared evidence violates basic discovery fairness. It hints at either disorganization or manipulation. In real courtroom strategy, that's enough to create doubt not just about the accusation, but about the state's competence. Viewers watching this will sense the defense is cornering the prosecution with precision, forcing them to admit they're building an argument on missing proof. At this point, even Judge Simpson's silence feels heavy. You can tell he's registering every inconsistency.
However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report.
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, then generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual.
This is where emotion begins to creep in. The defense isn't just questioning facts anymore. They're calling out the accuser's absence as proof of doubt. In law, a witness not showing up can destroy credibility, especially when that person is the only source of the story. The defense's tone is both confident and confrontational, pushing the logic that truth doesn't hide. It's a high-stakes gamble, though. Judges don't always appreciate emotional reasoning, but this moment feels like the turning point of the case. The more the attorney presses, the clearer it becomes that the state's foundation is crumbling. Still, there's a risk. If the witness appears later, all of this passion could backfire. But for now, it's a masterclass in courtroom control.
The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Well, you know, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate. There's just simply, there's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses, none. Wait a minute, he's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Oh, you know, without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse force. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
oh, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast.
Judge Simpson finally snaps. His warning to defense attorney Vincent changes the temperature instantly. What was once legal chess just turned into open tension between bench and counsel. This moment reveals how judges manage authority. Once patience breaks, tone becomes enforcement. From a viewer's lens, this is where drama peaks. The judge's irritation isn't just about attitude, it's about control of the courtroom. Attorneys can argue fiercely, but defiance risks sanctions or worse. You can see Vincent still trying to stand his ground, but Simpson's tone makes it clear. One more push and he's crossing a line. This power exchange reminds everyone that even the best arguments must respect hierarchy. Law isn't chaos. It's theater ruled by one director, the judge.
Ms. Kirby, you may continue.
thank you. I also explained in my motion that the Romulus police report is different than the two other contacts that this victim had with the sheriff's department. I've included those police numbers. Those are also in the motion. So I'm not sure what he means on I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this as serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out, no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court. But she is not present, and regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing.
Here, the prosecution seizes control again, grounding their stance in procedure. They remind the court that the rule doesn't require the witness to appear as long as the state can legally proceed. This moment demonstrates the thin yet powerful line between technical law and moral persuasion. On paper, the prosecution is correct. Hearsay can suffice in certain hearings, especially for bond violations. But to the audience, it feels hollow. The woman's absence continues to cast shadows over the state's claim. It's one of those gray zone moments that show how justice often relies more on process than proof. The prosecutor sounds confident, but the moral weight leans toward the defense. This back and forth keeps viewers locked in. Who's really in control here? The facts or the rules?
Thank you.
Anything else, Mr. Benson?
And if hearsay allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Simpson is not here. But if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's
snitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why did he turn himself in between the time I revoked his bond and today? Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
I mean, we were going to be here today. That's
not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I mean,
Way the wrong answer.
I'm sorry, man.
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client defendant remanded. Take you. Court's gonna stand in recess.
Explosion. The judge's fury detonates. His words are sharp, and his tone leaves no doubt. He feels deceived. When Judge Simpson says he's furious, it's not theatrics. It's genuine frustration with what he sees as a betrayal of courtroom duty. The defense attorney's earlier claim that his client misunderstood court instructions now feels like damage control. This is where the courtroom transforms from debate to accountability. You can see the hierarchy in motion. Judge Simpson reasserting dominance over the chaos. To viewers, it's shocking but mesmerizing. This is real power. When authority stops listening and starts ruling, the defendant's fate shifts instantly, reminding everyone that one bad exchange with a judge can undo weeks of defense strategy.
This is Cameron Carter. Recall.
It looks like we have to control.
Now, Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense, and I think you ought to know that. To willfully tell a client, or even to intimate to a client, that they should in some way disobey a court order.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week, and that come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor, this is a horrible mistake, and I'll fall on my sword for it, but it is a misunderstanding, not any, in no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And must have told him that a dozen times, something that every time I've talking to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part, and I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working on another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then too. Definitely. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, the court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th, if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded.
Your Honor, may I approach?
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
Are we going to argue these other motions first, or where are we with these 404Bs?
I believe Mr. Fikowski still wants to proceed on them, and I'm prepared to argue them as well.
All right. Guys, give me a few minutes and then I'll come back and I'll court standing recess.
Please subscribe to help the channel.
The dust finally settles. Judge Simpson resets control, scheduling new hearings and revoking bond. It's his way of reestablishing order after chaos. The courtroom that started with uncertainty ends with structure and consequence. What's striking is how quickly the tone moved from argument to judgment. This case is a blueprint for how courts balance emotion, procedure, and credibility. The defense fought hard but got tangled in communication failures. The prosecution leaned on technical rules, and the judge demanded accountability above all. For viewers, it's a reminder that courtrooms aren't just about guilt or innocence. They're about control, discipline, and truth management. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
When the phone starts recording, people reveal who they really are. Victims get louder, aggressors get bold, and bystanders suddenly vanish. Cameras don't just capture the truth, they corner it.